crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. Got a really interesting show, a topic of conversation that we are convinced will matter and be important to a number of you, if not all of you. So looking forward to that conversation. Got a great panel of experts here to deal with it. Before we get started, a couple of ground rules, just in case this is your first time with us. You'll see at the bottom of the screen ways you can join our conversation. Call, text, email, whatever you're comfortable with. 844-LAW-TALK is the number you need to know for all your needs at any time during the show or otherwise. Also, Hollis Wright makes available attorneys who are standing by right now to speak with you. You can call, text to get in touch with them if you have a legal question, an opportunity to get some great free legal advice. Leading our conversation tonight, he's the managing partner of Hollis Wright. Josh Wright, good to see you, sir.
Good to see you too. How you doing?
Doing very well. How are you?
Well, I'm great. And you know, Dave, we've done a series of social distanced shows during the COVID period. Mm-hmm. We finally decided it was time to change things and try and get ourselves a little bit back more to normal and to the center where I felt like we were before COVID. And we're bringing our first guest on today for the very first time. Maureen Evans is with us to talk a little bit about probate law. And first of all, welcome. So glad to have you.
Thank you.
I told you before we started that you were the first guest back. So I don't know if that's good or bad, but we're super excited to have you here.
Well, thank you so much.
You know, this is just such an interesting time. And, you know, we were talking before we even started how the legal world has changed so drastically during COVID, and your practice, I know, has changed drastically during that time and probably starting to get a little bit back more to normal, but maybe not. You tell us.
Yeah, you know, has been a very, very strange year, I think, for everybody across the board. The courts have had sort of different types of orders put in place, freezing jury trials and things like that. I feel like things are starting to pick up a little bit. Yeah. And I certainly am excited to see some of these things move forward.
Can I ask you both, for both of you, what have you maybe kind of been forced to do, because both of you run law firms that are small businesses, what have you been forced to do due to the coronavirus that you think that's kind of been a positive and an opportunity that you all will continue to do once, you know, all the restrictions are listed?
Well, I'll go first and then let Maureen talk. But, you know, one of the things that I've been able to do is to catch up on a lot of the things that were important in the litigation world that I had to gloss over more to keep my practice. I kind of look at it as spinning plates sometimes.
Yeah,
you see the person spinning a plate, and then you got to give attention over here and then attention over here. And that's litigation. Those are different cases, and you have to give attention to those cases if you want them to be successful and you want to represent a client in a positive way. And so along the way, little things like sitting down, spending more time talking with the client about the specifics of the case and answering what we call discovery and going through documents that are produced where I used to have a paralegal maybe do that. Now I'm doing it personally. So those are some things that have allowed me to recognize getting my sleeves rolled up inside my case. I was allowed to do that during COVID, and I'm going to continue that moving forward. So that's one of the things that I've seen that I think will help me represent my clients in a better way. How about you, Maureen?
You know, it's interesting you say that because I feel the same way. I've started these different types of documents in a lot of my cases, especially back when everything shut down big time back in the spring. I had an opportunity to sit at home and just dig deep into piles of medical records or whatever type of records I needed to go through for these cases and do sort of in-depth reviews and outlines and things, and that's a practice I look forward to continuing because it's really it's eye-opening. I'd done it before, but it was on a different level because the time was available.
Yeah. I've always said too that, you know, he who knows the facts or she who knows the facts of their case knows the case the best and knows how to properly litigate and successfully litigate that case for the benefit of the client. And so that has been eye-opening that I needed to roll my sleeves up a little more than probably I used to do it earlier in my practice, but then I used paralegals along the way.
Yeah.
And the paralegals play an important role still, but it allows me to roll my sleeves up a little bit more to learn a little bit more of the case. That helps. All right, we're talking about probate law, so let's move on to probate law.
Sure.
First, how did you get in this area? Because this is probably the most requested topic we have.
Is it?
Really is.
That's great.
Because it impacts so many different people. If we're talking about wills or powers of attorney, whether the wills are living wills or post-death wills, guardianships, those are just questions I get all the time and our firm gets all the time. How did you get in this area of the law?
You know, I work at a litigation firm, so I'm a litigator, but I just like probate. And I slowly started to just attend CLEs and pick up various probate projects that we had at the firm. And I just really started to dig in, and I really enjoy it. And I continue to do litigation, and I do probate litigation. But as far as just the facts of wills and being able to help people, I think that I say this a lot, doing a will is a wonderful gift for your family. And I know that that sounds funny because nobody wants to talk about passing away or thinking about dying, but having these documents in place is really a gift for your family if they're done properly, because it allows your wishes to be expressed and they're done in a way so that they're legally binding. They could be upheld in a court of law.
How do you explain to people when people say, hey, what is this topic, probate law? How do you explain that? I mean, how would you explain it when someone asks you what that really is?
You know, that's an interesting question. When I think of probate, I think of wills and estates and, of course, guardianship and conservatorship. There's adoption that's handled in probate. The probate court handles a lot of different matters. But generally, when I get that question, it is about wills, because that is something that everybody at some point could need. Everyone is going to pass away. And so that is a document that all of us should have.
Talk a little bit about, I know we have this concept that has become very popular over the last decade of living wills versus, wills at the time of death. How do those things, can you talk a little bit about those?
Yeah, living wills are wills that, again, a gift to your family. It basically tells your family it's a medical directive. It tells your family what I want if I become incapacitated, I am not coming back. You can make it as specific as you want. There's a form that the state of Alabama recognizes. It can come down to food, water, what you want, what you don't want. My preference is to keep it simple and to say, hey, if 2 doctors have decided that I am not coming back, and one of whom is my normal attending physician, then these are my wishes. These are my wishes here, and I want to be made comfortable. And that document tells your family back when this person was healthy, or maybe not, but these are their wishes. When they were clear thinking, this is what they wanted. And so I don't have to make that decision. And in those really tough times when family members are struggling, I think that that's a very important thing.
Do you sit down a lot of times? Are you required to sit down with a family to try and figure out from a living will perspective or a medical directive what they need? Is that the easiest way to do it?
I generally start the conversation just asking what they want, and it goes from there. It's organic. It's not, because it's a difficult thing to talk about.
Yeah. So I know we're getting ready to go to break. When we come back, though, I want to talk about actual wills that we all talk about in layman terms when we use the term will. I want Maureen to talk a little bit about that process, how you set it up, how to make sure that it's going to be legally binding down the road. Those are all good topics for us.
That sounds good. We're going to step aside right here. As we do so, a reminder, we'd love to have you join the conversation. That info at the bottom of your screen. Stay with us. We are coming right back.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys. I started practicing law more than 20 years ago with a mission: advocate for personal injury victims in their darkest days. Recognizing that there were others who stood with me in that purpose, we built the Hollis Wright team from the ground up. Now with 25 employees here to help personal injury victims when they need it the most, our team is here for you. If you've been injured in an accident, always make Hollis Wright the first law firm you call. At Hollis Wright, results matter.
Welcome back in to The Attorneys. Before we get back to our conversation on probate, wills, trust, all that sort of thing, just a reminder, attorneys from Hollis Wright, they're standing by right now, even as we speak, the opportunity for you to get some free legal advice. It's confidential. It's off the air. The number you see right there on your screen, 844-LAW-TALK, is how you get in touch with them. But again, a neat thing that Hollis Wright makes available during the show tonight. So if a question pops to mind and you would rather get in touch with someone about that, the opportunity to speak with an actual attorney from Hollis Wright is yours for the taking. Josh?
So when we went to break, one of the things I wanted to talk about was this concept of, just in general term, how do you set up a will? How do you make that will binding to make sure that you're protecting your resources, assets, and your family moving forward? So let's kind of dig into that a little bit. What's the starting place with a will? I mean, where do you generally start with a family?
Okay, so if I have someone come into the office, generally they know what they want, in the sense that they know where they want their belongings, their assets, their finances to go. And we start there. So if we're dealing with a husband and wife or a spouse and spouse, then they come in and they generally want what's called a reciprocal will, meaning that their assets, their wills will mirror each other. Oftentimes people think that they can have the same will if they're married. That is not true. We need to have separate wills. But we start by asking what they would like. If they've got minor children, then that's a separate consideration. We've got to make sure that there's a testamentary trust tucked into the will to protect the children, to make sure that we've got a guardian lined up to take care of the children, a trustee, if not the same person as the guardian, who will manage the finances, because you don't want your 15-year-old inheriting all of your assets or all of your money at that age. At least I don't want my 15-year-old inheriting that. And so you want to protect the child and protect the assets for their benefit. And so there's all kinds of different considerations. And so it's really a conversation that I have with the individuals about what they are hoping to achieve and what we can do for them to help them achieve that. Sometimes they may have ideas that they want to put specific, I want, have specific wishes that go in the will. They can put those in there. That doesn't necessarily mean that some of them are going to be legally binding, but we can at least express what their desire is on that point. Does that make sense?
Yeah, for sure. And you don't know you need a will until you need a will, you know what I'm saying? Yeah. So you got to get this thing done now.
You got to get it done. A question we've got here, can I change my will after it's signed?
Absolutely. And you know, I've got a funny story about that. My husband and I, we were boarding a plane a few years ago, and it dawned on me the night before. It was just an adult trip with my adult family members, and all the kids were going to stay home. If that plane went down, then it wiped out everybody who was going to take care of my children. And so the night before this trip, I'm at the office having my husband, we're redoing our wills because I'm trying to make sure my kids are protected if this plane goes down. And of course it didn't, everybody's fine. But I say that because you can easily redo your will. You can execute a new will that revokes the prior will. I often like to have the individual bring their old will in, and once we have the new one executed, they tear it up. Some of these old-fashioned things, just write void on the will. Right. All of these things that indicate that you, as the person who executed this old will, no longer want this one to be the one that's binding. So you can destroy it, all kinds of things.
What are some of the things that are required to make sure that it is binding down the road?
Okay, so a couple of things, and it is specific. the age to execute a will is 18, which is different than the age of majority in the state of Alabama. Age of majority is 19. So all you have to be is 18 years old. You have to be of sound mind. The document has to be in writing. And so you need to say, I, John Smith, I am of sound mind and wish as follows. And then you list down the beneficiaries and who you want to give your items to, who you can name an executor. But as far as the actual requirements, you got to be 18, of sound mind, must be in writing. We've got to have 2 witnesses who witness you sign the document or have someone sign on your behalf.
Right.
And the person executing the will, the testator, has to sign as well. Okay? So all of those need to be part of the document. And you can have a very short will.
Yeah.
I recommend getting an attorney because there are a lot of other things than just saying, I want to give, Jane Doe X, Y, and Z.
Yeah.
That is a will if it's executed properly, but you need to make sure, you want to have an attorney because they can make sure that an inventory is not necessary, a bond isn't necessary, that the person who is in charge of your estate can sell the property without petitioning the court. There are a lot of different things that an attorney can tuck into the will to make sure it's as easy as possible in your family.
I'm assuming you unwind bad wills all the time.
It's not so much unwinding. I'm dealing with one right now that was handwritten, and it's a lot more work for the family is what it boils down to. And it's a lot more emotional too, because then you've got people who are thinking that they can challenge the will, and there are just a lot of different things.
Another reason why having a lawyer involved in the early stages can really help for sure.
Something I kind of hear some folks saying, I'm not a Kennedy, I'm not a Trump, right? I don't have a super complicated fortune to figure out, maybe just a house and some other things. Even for folks who do not consider themselves, wealthy and have a whole lot to pass on, do you still advise them to get a will?
Absolutely. And I'll give you another just real life example here. I have a friend who I had the exact same conversation with. He leads a very adventurous lifestyle, does some high risk, has high risk hobbies.
Right.
And so I was talking to him and, just out of concern saying, this is something that, you should think about.
Right.
And he said, well, I don't have anything. I just have a house and I have, my bank accounts, and he's got personal assets, but he's like, it's just me. I'm not married. I don't have kids. But he does not like his sister, okay? And his parents have passed away. So if you do not have a will, then the Alabama law dictates the distribution of your assets. If you have not put it into a valid will, then Alabama law steps in and says, okay, well then your assets will go to so-and-so. In his circumstance, with no parents, no spouse, no children, his assets would go to the sister he did not like. And that was motivating to him, So the will gives you control. You may not have a lot, but you probably do care about where that goes.
Right.
Yeah.
And that's
interesting. Well, a real world example. So delve not too deep, but a little bit further. The legislature in their wisdom has created a series of rules that folks that don't have a will follow after their passing. It's called intestate succession.
Correct.
So the legislature has created some rules that do protect people that don't have wills, but they lose all authority. The family really loses all authority on how to divide things up because it's going to be divided based on the statute. Is that fair?
That is fair.
Okay.
That's correct.
Yeah.
And a lot of people think, well, I'm married. They assume that just because you're married and you have kids, your wife or husband or your spouse, they're going to get everything. And that's not necessarily so.
Yeah.
So a will really does protect your family, and it just streamlines everything.
And it's definitely not true if you have stepchildren and real children too, and that the intestate succession it impacts all those things.
Right.
So getting a will is really important. When we come back, we're going to talk about some of the other probate-related topics like guardianships and some of the other things, and I think that'll be good for the viewing audience.
All right. We're stepping aside our final break of the evening. As we do so, a reminder, Hollis Wright does an incredible job on social media, Instagram, Facebook, Twitter. Just search Hollis Wright and you'll find them there. Great educational, informational resource, and y'all are always giving stuff away too. So just for following, Hollis Wright can be financially beneficial to you. So check them out right there all over social media. Hollis Wright. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis, Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 4-in-1, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? First, do your research. Look the firm up on the internet. Learn about the cases they handle and the results they get. Second, find out what clients are saying about the firm. Many websites provide client testimonials or have a star ranking system. Use those to your advantage. And finally, talk with a lawyer from their office and ask them questions. Questions about the volume of cases they handle. Do they return phone calls? Are you just a number or a client that gets the attention you deserve? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a confident lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys. Under 6 minutes remaining in the show, so if you want to take advantage of that opportunity to speak with some of the attorneys from Hollis Wright who are standing by live, take advantage of that opportunity. About 6 minutes remaining for you to do so. Josh?
All right, so let's talk just a minute about powers of attorney. We get a lot of questions during probate shows about getting a power of attorney and what impact it can have. Just kind of unwrap that topic a little bit if you can.
Yeah, powers of attorney, that's a very powerful document. And what it is basically if you choose to execute a power of attorney in favor of an individual, you are essentially saying that individual can step into your shoes and be you. They can handle your finances, depending on the scope of the power of attorney. But if you are giving a full power of attorney to a person, they can be you. They can step into your finances, they can go through your bank account, they can manage your bills, they can, in some instances, if there's a healthcare proxy designation, then they can make healthcare decisions for you. So that's a very, very powerful document. However, it's a very useful document in certain circumstances. If you've got an individual that you know that he or she is facing a terminal illness or some sort of medical condition that is going to hinder their ability to make meaningful decisions, then they may want to go ahead and execute this document while they are still in the right frame of mind to allow individuals to make those decisions later on when they are no longer healthy and able to handle those decisions on their own.
You can limit your power of attorney too, can't you?
You can.
Like, for example, we have, in circumstances where we resolve cases, we have a limited power of attorney to endorse a check for a client because it's going to trust, and then it will be allocated to the client, little things like that. So there are ways that you can limit those things too, are there?
Absolutely. In the context of estates and probate, often we don't see these limited powers of attorney. We're talking about an individual giving another person full authority to act on their behalf because they're trying to prepare for these circumstances that may happen later in life. Either way, though, there's got to be an individual that you absolutely trust if you are signing them up to be your agent under a power of attorney.
Very important stuff.
Help us understand some of the terminology you all kind of toss out there. One phrase you all have been using quite a bit. Help me understand, what is a guardianship?
Yeah, okay, guardianship is, so say we don't have a power of attorney or we don't have some sort of healthcare proxy, a person nominated to make healthcare decisions on your behalf.
Okay.
In that circumstance, if the individual becomes sick later on and is no longer to care for him or herself, then you would need to petition the court to have a guardian appointed for their health and well-being. This guardianship also applies for minor children, so children who are under the legal age of 19. Okay, if in that circumstance, if their parents pass away, or there are a lot of different varieties and a lot of different circumstances under which a guardian may be needed, but you can petition the court to have a guardian appointed to care for the child if they're under the age of 19. So that's what that means.
Okay.
It's a legal process, and in terms of the power of attorney and dealing with an adult who's incapacitated, the power of attorney sort of short circuits that, so you don't have to go to the court to ask for a guardian or a conservator, depending on what the power of attorney says.
Do most lawyers that fall into the category of, I know you do the litigation side too, but that fall into the probate side, are they willing to meet and talk with someone initially to try and gather information about what they need without charging them an arm and a leg, so to speak? I mean, is it a pretty easy process to have someone sit down with you and go through some of this stuff?
Yeah, I try in that initial intake phone call, I try and get a pretty good a pretty good idea of what the individual is looking for, to see if we can help them, and if they would like to meet in person, we do that too. So yes, there are absolutely ways, at least in my personal experience, to do that.
Get a lawyer involved.
That's it. That's the takeaway here. A minute and a half remaining. Time enough for a quick final thought from both of you. Maureen, if you would, you go first, please.
Please get a will. I know that sounds silly, but these documents really make it very easy on the family going forward, and it's a very, very important document, in my opinion.
Yeah, and you want that document. You want that document to be something that is going to be approved by the court, and something that actually allows you to direct your resources and assets and those things. Getting a lawyer involved early is really, really smart. You can always make small adjustments to your will as needed. Maureen's story about getting on a plane is a very similar story that I have with my wife, and my wife was more pushing me to try and do something like that, and we did, and it gave me some level of peace. But having a lawyer get involved to make sure that you're making good decisions and making you think about all the little things, like Maureen talked about whether you need a bond or not need a bond, whether or not you've got to petition the court for certain things. Those are all important things that getting a lawyer involved in is important.
Really good stuff.
Thanks for being on.
Yeah, thanks for having me.
Thank you both for being here. Thank you. Great job. Important conversation. Glad we had it. And thank you, as always, for being here with us. We'll look for you next time. Have a great week. We'll see you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.